Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss a consumer case decided by NCDRC, National Commission for Dispute Redressal. NCDRC, it is the highest commission in India. So, two members of the committee, Binoy Kumar and Justice Sudeep Ahluwalia, in consumer case number 3681 by 2017 on 27/12/22 held that landowner is jointly and severally liable along with the developer for the deficiency in service. So you can cite the case law as Prakash Telkar and Vijay Kaladki plus and 50 others versus ND Developers Private Limited, so and 5 others. This happened in Karnataka state. So it is a routine practice that people will give beautiful brochures. So they will give highest publicity so that the common man will be attracted. He will deposit some money, he will give some money in advance, but they fail to deliver the so-called apartments in time. Same is the case in this case. Right? So actually this Prakash Telkar, you can call them as the consumer case law, complainant opposite party, accused and so the complainant and others, actually they were induced by the advertisement given by the opposite party one, that is ND Developers. They called it as ND Laurel, Laurel. So that brochure they have seen, they were attracted, and ultimately in 2009 or so, so they have booked 1 unit each. So likewise, Prakash Telkar, then Vijay Kalagati and 50 others, total 52 others, they filed the complaint against the so-called ND developers. These developers, actually, they took the land from the owner and maybe 50-50 or 60-40 like that. So the development agreement was written. Ultimately, they have lured the complaint others that they will complete the construction and hand over the plots by 2012 or so. But it is all on paper. But nothing was done. Even though they undertook the construction of the flats, so even though there is agreement between the landowner and the developer, but by December 2012, the work was not completed. Even though in the agreement itself there is a grace period of 4 months for arranging the lift, for arranging the staircase and all things, a 4 months period was also given, but that was not also done. He failed, and ultimately this man failed to give the so-called occupancy certificate. Therefore, they have filed a case before the commission since there is a deficiency of service. Now, ND, that is developers, on their behalf, please remember, they say that the petition, the case is barred by limitation because 2012, they have filed the case in 2020. So, the period of limitation, you remember in a consumer case only 2 years. After that, you cannot file the case. Period of limitation is over. And out of these 52 complainants, 18 had taken over the possession of the plots. Actually, the flats are 100. So out of them, some people, of course, out of disgust, so many reasons, so they might have occupied. So therefore, and now the landowner, he says he had no role. He has just signed the development agreement. So those people wanted to complete the same. They are the real construction workers. They have to look after. I do not have any say except taking money or except taking a part of the flat. Suppose if 4 floors are there, 1 floor will be given to him. But court did not agree. No, it's not correct. You are jointly and severally liable for the deficiency. So definitely the NCDRC noted there is abnormal delay in completion of the project. The complaints cannot wait for indefinite period. Already 9 years. Suppose if not 2012, it should have been completed by 2014. But some occupied in 2016 out of disgust, and 9 years passed away without any completion of the project. So definitely the builder as well as the developer, the owner as well as the developer, they cannot they cannot shirk away their responsibility. So they cannot ask the buyer to take possession without completing all the formalities like staircase, roof, lift, water connection, plumbing, all these works. So definitely there is a deficiency in the service. So the Honorable NCDRC stated that the persons who do not want to occupy, for them, the developer as well as the owner, they have to repay the entire amount they have paid with 9% interest. So within 6 months they have to do it. If not, the percentage of interest will be 12%. Likewise, for the people who have already occupied, so the developer and owner, they have to complete the construction within 1 year. So the occupancy certificate should be given to them within 6 months. This is also so. And if not, they have to pay compensation at the rate of 8%. Of course, if it is beyond 12 months, same 12% interest. Very good judgment by the Honorable NCDRC, Justice Sudeep Ahluwalia and Binay Kumar. They have delivered the judgment. Normally, such type of cases do come to you as advocates. So you can cite the case law as a landmark judgment. So with this, I am concluding. Please read the case law. That is Prakash Telkar and Vijay Kalagatti and 50 others versus ND Developers Private Limited and 5 others. Right? So with this, I am concluding. Thank you very much.